Welcome to Motivation at Hand, Ma. To know is to know how. Part 5 continued. Case 1:23 cr-00257-TSC Document 1 filed August 1, 2023. The defendants attempt to leverage the Justice Department to use deceit to get state officials to replace legitimate electors and electoral votes with the defendants. 70. In late December 2020, the defendant attempted to use the Justice Department to make knowingly false claims of election fraud to officials in the targeted states through a formal letter under the acting Attorney General's signature, thus giving the defendants lies the backing of the federal government and attempting to improperly influence the targeted states to replace legitimate Biden electors with the defendants. 71. On December 22, the defendant met with co-conspirator 4 at the White House. Co-conspirator 4 had not informed his leadership at the Justice Department of the meeting, which was a violation of the Justice Department's written policy restricting contacts with the White House to guard against improper political influence. 72. On December 26, co-conspirator 4 spoke on the phone with the acting Attorney General and lied about the circumstances of his meeting with the defendant at the White House, falsely claiming that the meeting had been unplanned. The acting Attorney General directed co-conspirator 4 not to have unauthorized contacts with the White House again, and co-conspirator 4 said he would not. 73. The next morning, on December 27, contrary to the acting Attorney General's direction, co-conspirator 4 spoke with the defendant on the defendant's cell phone for nearly 3 minutes. 74. That afternoon, the defendant called the acting Attorney General and acting Deputy Attorney General and said, among other things, "People tell me, co-conspirator 4 is great. I should put him in." The defendant also raised multiple false claims of election fraud, which the acting Attorney General and acting Deputy Attorney General refuted. When the acting Attorney General told the defendant that the Justice Department could not and would not change the outcome of the election, the defendant responded, "Just say that the election was corrupt and leave the rest to me and the Republican congressman." 75. On December 28, co-conspirator 4 sent a draft letter to the acting Attorney General and acting Deputy Attorney General, which he proposed they all sign. The draft was addressed to state officials in Georgia, and co-conspirator 4 proposed sending versions of the letter to elected officials in other targeted states. The proposed letter contained numerous knowingly false claims about the election and the Justice Department, including that a. The Justice Department had identified significant concerns that may have impacted the outcome of the election in multiple states. b. The Justice Department believed that in Georgia and other states, 2 valid slates of electors had gathered at the proper location on December 14, and that both sets of ballots had been transmitted to Congress. That is, co-conspirator 4's letter sought to advance the defendant's fraudulent elector plan by using the authority of the Justice Department to falsely present the fraudulent electors as a valid alternative to the legitimate electors. c. The Justice Department urged that the state legislature convene a special legislative session to create the opportunity to, among other things, choose the fraudulent electors over the legitimate electors. 76. The acting Deputy Attorney General promptly responded to co-conspirator 4 by email and told him that his proposed letter was false, writing, "Despite dramatic claims to the contrary, we have not seen the type of fraud that calls into question the reported, and certified, results of the election." In a meeting shortly thereafter, the acting Attorney General and acting Deputy Attorney General again directed co-conspirator 4 not to have unauthorized contact with the White House. 77. On December 31, the defendant summoned to the Oval Office the acting Attorney General, acting Deputy Attorney General, and other advisors. In the meeting, the defendant again raised claims about election fraud that Justice Department officials already had told him were not true, and that the senior Justice Department officials reiterated were false, and suggested he might change the leadership in the Justice Department. 78. On January 2, 2021, just 4 days before Congress's certification proceeding, co-conspirator 4 tried to coerce the acting Attorney General and acting Deputy Attorney General to sign and send co-conspirator 4's draft letter, which contained false statements, to state officials. He told them that the defendant was considering making co-conspirator 4 the new acting attorney general, but that co-conspirator 4 would decline the defendant's offer if the acting attorney general and acting deputy attorney general would agree to send the proposed letter to the targeted states. The Justice Department officials refused. 79. The next morning, on January 3, despite having uncovered no additional evidence of election fraud, co-conspirator 4 sent to a Justice Department colleague an edited version of his draft letter to the states, which included a change from its previous claim that the Justice Department had concerns to a stronger false claim that as of today, there is evidence of significant irregularities that may have impacted the outcome of the election in multiple states. 80. Also on the morning of January 3, co-conspirator 4 met with the defendant at the White House, again without having informed senior Justice Department officials, and accepted the defendant's offer that he become acting attorney general. 81. On the afternoon of January 3, co-conspirator 4 spoke with the deputy White House counsel. The previous month, the deputy White House counsel had informed the defendant that there is no option in which you do not leave the White House on January 20th. Now, the same deputy White House counsel tried to dissuade co-conspirator 4 from assuming the role of acting attorney general. The deputy White House counsel reiterated to co-conspirator 4 that there had not been outcome determinative fraud in the election and that if the defendant remained in office nonetheless, there would be riots in every major city in the United States. Co-conspirator 4 responded, "Well, Deputy White House counsel, that's why there's an Insurrection Act." 82. Also that afternoon, co-conspirator 4 met with the acting attorney general and told him that the defendant had decided to put co-conspirator 4 in charge of the Justice Department. The acting attorney general responded that he would not accept being fired by a subordinate and immediately scheduled a meeting with the defendant for that evening. 83. On the evening of January 3, the defendant met for a briefing on an overseas national security issue with the chairman of the Joint Chiefs of Staff and other senior national security advisors. The chairman briefed the defendant on the issue, which had previously arisen in December, as well as possible ways the defendant could handle it. When the chairman and another advisor recommended that the defendant take no action because Inauguration Day was only 17 days away and any course of action could trigger something unhelpful, the defendant calmly agreed, stating, "Yeah, you're right, it's too late for us. We're going to give that to the next guy." 84. The defendant moved immediately from this national security briefing to the meeting that the acting attorney general had requested earlier that day, which included the acting attorney general, the acting deputy attorney general, the Justice Department's assistant attorney general for the Office of Legal Counsel, the White House counsel, a deputy White House counsel, and a senior advisor. Co-conspirator 4. At the meeting, the defendant expressed frustration with the acting attorney general for failing to do anything to overturn the election results, and the group discussed co-conspirator 4's plans to investigate purported election fraud and to send his proposed letter to state officials, a copy of which was provided to the defendant during the meeting. The group discussed co-conspirator 4's plans to investigate purported election fraud and to send his proposed letter to state officials, a copy of which was provided to the defendant during the meeting. The defendant relented in his plan to replace the acting attorney general with co-conspirator 4 only when he was told that it would result in mass resignations at the Justice Department and of his own White House counsel. 85. At the meeting in the Oval Office on the night of January 3, co-conspirator 4 suggested that the Justice Department should opine that the Vice President could exceed his lawful authority during the certification proceeding and change the election outcome. When the Assistant Attorney General for the Office of Legal Counsel began to explain why the Justice Department should not do so, the defendant said, "No one here should be talking to the Vice President, I'm talking to the Vice President," and ended the discussion. To be continued. Part 6. The defendant's attempts to enlist the Vice President to fraudulently alter the election results at the January 6 certification proceeding. The world is watching. The children are watching. Much appreciation to you for giving of your time with us at Motivation at Hand. To know is to know how. We trust you will come back soon.